Well, good afternoon, everyone. Very excited for this education session. This is certainly near and dear to my heart. Welcome. My name is Marissa Rauschway. I am the head of the franchise group at my law firm based out of New York and New Jersey, CSG Law. I deal with all things franchising on the litigation side, as well as the corporate side. And I am your moderator today for this session. Dodgeball is dangerous. Avoid getting hit by drive-by lawsuits and other legal perils. So hopefully that's the session that you guys are looking to attend. And to my left are our esteemed panelists. I'll have them tell you guys a little bit about themselves, but I have Jennifer Rusi here from Jackson Lewis, an employment and disability access attorney, and Anand Patel from the law office of Anand Patel. And like I said, they'll certainly give you more of their background. But before I turn it over to them and we can get going on the seminar, I just sort of wanted to lay the foundation as to what we're going to be talking about here today. The goal of this seminar is to just give everybody in the room a bit of a heads up on sort of best practices and things that you guys can look out for while you're running your businesses to hopefully avoid issues in the future. No seminar can give you everything to look out for, being a business owner, which I'm sure many people in the room are. But we're going to try to give you guys some tips, some best practices, some issues that hopefully when you leave here today, you're better equipped to go about your day as business owners, presumably in the hospitality and hotel industry, with what to look out for. Again, some best practices, so to hopefully learn some things that my clients, and I'm sure some of my colleagues' clients have had to learn. I'll call it the hard way. Getting involved in lawsuits or administrative proceedings or whatnot, where they find out that they just didn't know what they didn't know. And sometimes once you get involved in proceedings like that, it can be too late, or you can get to a point where you say to yourself, like, oh, if I just knew this, 6 months ago, I could have avoided something, down the line. I do have to say that, we're all attorneys here. This is not legal advice. We have to say that to you. This is for educational purposes. This is not specific to anybody's circumstances here. But again, we're just trying to give you guys a heads up of things you should be aware of as you go about your day-to-day business. So with that, I am going to turn it to my colleagues over here. Jennifer, Anand, who wants to take it away?
Mic check.
Is this thing on?
All right, well, I'll start, and let's do a quick show of hands here. So you guys can see the first slide. We've got Americans with Disability Act, the ADA. We've got accommodations claims, garnishment, wage and hour claims, mechanics liens, misclassification. Hopefully these are familiar, but not too familiar. So show of hands, how many people in this room know someone who's had to face a complaint related to one of these issues? Please don't be shy. All right, so a good amount of you. We'll start with the Americans with Disabilities Act, a popular one. This one always kind of surprises, well, I shouldn't say always, but it has a tendency to surprise property owners because, these claims, they go straight into federal court. There's no notice requirement. You're just supposed to already know about it. And there's really no opportunity to cure before that claim is filed in court. And so you've got to get an attorney who's licensed in the federal circuits. It's expensive. And so part of what we're going to discuss today is things to look out for, what to do, and we'll start with that when it comes to drive-by lawsuits.
And an ADA claim is going to be your most common type of drive-by lawsuits. And just a little bit about us before you say, oh, you didn't introduce yourself. Jennifer Rusi, I'm an attorney. I'm a partner at Jackson Lewis, which is a nationwide, mostly employment law firm. We have 60 offices around the country, but we also have a few of us lucky attorneys who also do disability access work. And we do, all kinds of things with physical barriers, service animals, website accessibility, and we're going to be talking about all of that today. Anand, you want to tell them a little bit about you before we talk?
Yeah, so I'm a solo. I'm based in Cincinnati, Ohio. I'm licensed in Ohio, Kentucky, Florida. I do mostly commercial real estate transactions, so a lot of hotels, assisted living homes, retail centers, you kind of name it. So that's most of my practice, and then part of it's civil side litigation. So right up our wheelhouse. Collectively.
Right. Oh, and I'm in Nashville, Tennessee, and I'm also licensed in Kentucky and New York. And I used to be in Ohio, but I dropped that because I was never there anymore. But the way that ADA claims work, the Title III claims, and a lot of times people are surprised to know this, they don't have to have actually stayed at your hotel. This is the whole thing about why it's a drive-by. The attorneys can just drive by and look at the parking lot, and they can see, like, oh, they're missing a sign that's required. Oh, the striping's really faded. That's a violation. They can kind of guesstimate that the spots don't look wide enough. And then before you know it, you have a lawsuit. These lawsuits are really attorney-free driven because all you can recover under them is injunctive relief, which is the owner of the property has to, or the lessee has to fix whatever's wrong, and then they get attorney's fees. And so typically the main driver of these lawsuits are attorneys. They find someone who has a disability who they can use as their plaintiff, and they just go around and literally drive by. There was a period of time where they were doing Google Earth searches, and they were looking to see if pools had pool lifts. It was crazy. I think those have been stopped. It was a big thing in Florida a few years ago. But anyway, that's what happens. Somebody will drive by. They'll just be able to spot that there's something wrong, and then before you know it, you have received a lawsuit. And what do we want to do if you ever receive a lawsuit?
Call your attorney.
Do not ignore it.
Yeah, I'll just jump in on that. I think the do not ignore it is a really critical piece of advice, and it sounds obvious, and I'm sure we've all had this happen to us. But there is a tendency sometimes to get a piece of paper in the mail and put it on your stack of papers, and we'll get to it. But a key piece of information for a number, if not everything that we're going to talk about today, is that there is often a timer ticking on something. And sometimes it's clear on the face, sometimes it's not. So it's never the wrong move to address it immediately. So back to you guys.
Yeah, and I guess, it's kind of sad to say, but if you don't address it, you could be improving some other attorney's property, some other guest's property versus your own, right? So it's the wrong kind of PIP. We want to avoid this. But, really with this, with these types of claims, buying and selling is something that I imagine most of you here today have experience in on multiple occasions. But if you're on the buyer side, and you're going to try to buy a property, it's so important to just have a compliance done, an ADA compliance done, right? So when you have when you call your third party inspection company, make sure that they do ADA compliance. Not all of them do. Get that in writing from them so that you're from a timetable, from a due diligence standpoint, right? It may take 2-3 weeks to get that report back to you. You don't want to receive that report after due diligence has already expired, right? Because you've got some leverage there. Certainly as a buyer, you want to maintain that. And that could translate into costs, right? It could translate into a potential reduction of the purchase price. But these reports are going to tell you what the issues are, right? And those are issues that you do not want to ignore because, as a buyer, that's something that you're going to inherit, right? You certainly want the seller to take care of that before you close. And if they're not going to do that, get something in writing saying that, okay, we're going to give you X amount of dollars so that you do handle this, right? On the flip side, from a seller standpoint, you obviously want to be aware of your property being in compliance or not. But you can get ahead of some of these issues by just knowing where your property stands.
And let's say you're not interested in buying or selling. Here you are, just running your business. One of the things that we think is a great idea to avoid these lawsuits, and this is what hopefully every one of you can do, is just you can conduct your own audit or you can hire somebody. There's tons of ADA inspectors out there who will be glad to conduct an inspection for you, or some cities even have compliance departments. But if you want to go out there, the laws are not hard to find. You can just Google the standards for accessible design. There's a 2010 version and there's a 1991 version. And I think that you're going to probably fall under the 2010. And it just tells you a accessible parking space needs to be so many inches wide. There's a different width for van accessible spaces. They're going to tell you how many spaces you have to have, where exactly the striping needs to be. It's going to tell you what signage you need, how high the signage has to be. There's, all of that is stuff you can do with a tape measure, really. There gets to be a little more complicated stuff with the slopes of the parking lot, which is stuff you might want to get an expert to look at for you. But slopes are a little bit harder for the drive-by attorneys to determine. But so if you can just go out there with your tape measure and figure out what your parking lot looks like and look at the paint and get that taken care of, that is going to be a huge deterrent for, a lot of these drive-by lawsuits.
Yeah, and that way, if there's someone in a suit out there in your parking lot with the measuring tape, or someone you don't recognize, you can rest easy knowing that your measurements are according to code, right? So one of the scenarios that you can avoid.
Guys, let me ask you a question. I'm just thinking what might be going through some people's minds in the audience. So let's say you have an expert come in because you want to try your best to make sure that you're as protected as you can against these lawsuits. You have an expert come in, they assess what's going on in your property, they give you recommendations. Are you 100% in the clear? Is that how helpful is that if somebody, if you find yourself on the receiving end of a lawsuit like this?
Well, it's great if they have identified everything and you fixed everything. You can still get sued, you just have a great defense to it. But if something's wrong, then you're on the hook. It doesn't matter how hard you tried to get it right. If you don't get it right, it's what's called strict liability. You're on the hook.
Yeah, it does also open up some possibilities because, assuming you use an inspection company that has a good reputation, they have their own insurance coverage as well that might kick in here should they miss something. And so I think from that standpoint, right, you have a different avenue to explore that you otherwise wouldn't.
Great.
And not everything in a hotel is outside of the hotel, obviously. Once we get into the hotel, there's many, many things that need to be accessible inside the hotel. And it's really important that you are able to communicate the accessible features of your hotel and the accessible rooms to whatever third-party aggregator is, the hotel's rooms are available on. You can talk about the franchise aspect of this, but there's a whole other kind of lawsuit, which are more surf-by lawsuits that involve websites. And if you do not have, if a hotel does not disclose the accessible features of the hotel and the specific accessible features of the accessible rooms, such as roll-in shower with grab bars, things like that, you could also get sued. I had a big slew of those cases in California a few years ago. And so even if you don't run the website, you're giving it to, Expedia, or you're giving it to, one of the hotel franchisors, it is your responsibility as the hotel owner to provide that information. So you just want to make sure that you have provided that information, you have a record of providing that information to whoever's supposed to be putting it up, and then I would check and make sure that they're actually listing the information that you provided to them.
Yeah, very important and a great point. I think a lot of these websites, especially for the franchises, there's more control from the franchise end. But if you're an independent operator, something you really need to pay attention to. And Marissa, I know you have you got a background in franchises. Maybe you can add in there.
Yeah, absolutely. And this really goes to sort of everything that we're going to talk about today, where you're trying to avoid these lawsuits. So for people involved in franchise relationships, right, you are going to have this extra overlay, right? You're going to have these requirements that the franchisor is going to put on you. Every franchise system is different, but there are going to be requirements, and there are often going to be forms provided. They likely will have print on them that says, here's a form, but you need to go to your own attorney to make sure this form is compliant because, again, the franchisor doesn't want to be on the hook if anything is wrong with the form. Here's the bottom line. The bottom line is if the franchisor puts a requirement on you as part of a operations manual or even the franchise agreement, that is certainly not a defense if there is some sort of, if you get hit with a lawsuit or some court or administrative body says that, you're not doing something in compliance with the law, you can't turn around and say, oh, but my franchisor, required that, or I believed my franchisor required that. And really the way to protect against that is a couple of things. If you haven't signed a franchise agreement yet, and you're looking to the future and you want to try to protect yourself from anything like this happening, you can try to push for changes to the franchise agreement if needed, to try to push for terms that protect you from having to comply with certain provisions in an operations manual or a franchise agreement that could put you in hot water with some of these lawsuits. Again, not that the franchisor intentionally would do that, but that can happen. Some ways of doing that is to have an indemnity clause in there that basically says, look, if I'm following your system to the T and something in that system gives rise to some liability or a lawsuit, I can seek indemnity compensation from the franchisor. As you can imagine, franchisors don't like agreeing often to indemnity clauses. But again, and this goes with any franchise negotiations, candidly, depending on how much leverage you have, depending on how much they want you as an owner or an operator, these are the types of provisions that you can try to get in there. Another provision that you can try to get in there is something that says, look, if you impose a requirement on me that is effectively unlawful, then that requirement is void. That's another way of sort of protecting you from feeling like you're between a rock and a hard place. Like, I don't want to violate my franchise agreement, but I also don't want to be subject to these types of issues. If you are already in a franchise agreement, and so obviously you don't have the same ability to negotiate, practically speaking, that's usually just a conversation with your franchisor. At the end of the day, and I say this to clients all the time, when franchisor and franchisee are on the same page, that is when the system is working, right? So it's certainly to a mutual benefit for you not to have issues with these types of lawsuits. So that's really it on the franchise side of things.
So another issue that a lot of my hotel clients face is also inside the hotel, and it is something I think a lot of the franchisors probably have policies about, and that's service animals. How many of you have had any sort of a question about the service animals in your hotels? See, that is a big one. I get calls about all the time. Under the ADA, you can only ask, is this animal here to assist someone with a disability, and what is the service the animal has been trained to perform? That's it. That's all. You cannot ask for any sort of papers for the animal because guess what? Those aren't valid. They don't exist. If anyone ever says, I've got a certified service animal, Doesn't matter. You can order that certification off of Amazon. But you literally can't ask anything besides those 2 questions. And a service animal has to be a dog or a small horse. If somebody comes in with their service bunny, that is not a service animal. That is a pet. But it's really frustrating for a lot of hotel clients that I have is that someone has what is clearly a pet and they're passing it off as a service animal. And they say, oh, well, it is trained to sense my anxiety. Well, you kind of have to be stuck with that or make the difficult decision of, am I potentially violating the law? Am I going to charge them the pet fee? Risking litigation, or do I just, go for it and waive the pet fee? It's a really frustrating area that we have. And again, what I mentioned, the pet fee. If you do have a service animal, you cannot charge somebody for it. There cannot be special rooms that only the service animals go to. But I had a client recently, it's a hotel client, they had a casino. And they asked me a question. They're like, so we've got these service animals, but the guests are leaving them in the room all day. I was like, well, then it is not performing service. If it is just in the room, like you can tell them that is a pet and you can charge them. I've helped that client with some signage. That is some things, you can put up there like service animals permitted, other animals not, things like that. But it is a really delicate area. And you see people really trying to kind of bend the rules. But if you see an animal that is clearly or out of control, not house trained, is barking all the time, those are things when you can talk to the patron and say, hey, we need to remove this animal, things like that. It's, and I'm not saying to do that, but there are certain situations when you can go in and talk to somebody about a service animal, but generally it is a very touchy area for a lot of the patrons. And for the hotel owners, because you really are hamstrung by those 2 questions you can ask, and someone can just lie to you, and there's no way for you really to call their bluff, unless, of course, you have, like I said, the animal that is being left in the hotel room by itself, because then it is not performing service. Yeah, and we encourage questions. If you have questions, come.
What about, can you have a little bit of a service animal agreement or something that you can't leave it in the room and, that kind of thing? Because, like you said, we do get 90% that people say, yes, it is a service animal, and then next thing is they're barking and,
Right, that they're,
Was everyone able to hear that question? No. Okay. It was whether or not you can have an agreement in place with the guest regarding the service animal. And I don't think I repeated that exactly correctly, but I think Jennifer has the answer.
No, and I think essentially the question is, can you have that agreement that says, hey, I guess if the dog becomes disruptive, could you remove it or pay the pet fee? I mean, I guess it depends on what you're doing with regular pets. Do you allow pets in the hotel? Things like that. I think that's going to be a question if it's like, do we remove it or then all of a sudden, or is it a pet fee, or what do you do with regular disruptive animals? And I've actually never been asked that question, and I think you potentially, because that is under the law, the animal has to be not out of control. A service animal has to be, I was literally just looking at this, they're also supposed to be leashed all times, unless there's some very rare circumstances where they can be off leash, but they have to be under control. So if somebody just has, the dog is running around in the lobby, then that's a problem. You can certainly ask them to leash the dog. But I think also if it's not housebroken, if it is barking, that's something you can do. But in terms of the agreement, I guess you could. I would have to look into it. And I think it also depends on the jurisdiction you're in, too. Like, what is the, state law? Because what we're talking about is the federal law, which covers everyone, and state laws might be even narrower. But that's actually a very good question. I have to think about that. Have to look it up.
So if we can just repeat for what everyone, I think if I heard you correctly, that your franchisor has like template agreements that you can use. So I'm so glad you brought that up because that is a perfect example of what I was talking about before. So the franchisor, and there's nothing wrong with this. This is very normal and very helpful, candidly, will have forms often. But to Jen's point, just because the franchisor gives you that form does not mean it is lawful to use it in the jurisdiction that you're in. And my guess is that form has something on it that says you should have counsel, your attorney, take a look at this to make sure you're allowed to use this in your jurisdiction. So it's like an absolute perfect example of what I was talking about before.
But you also could have potentially an agreement, if the dog, destroys some property, that they would be financially responsible for it, just like a guest of the hotel, if, regardless of, if the guest is disabled or not, or you could, if the guest does something to the hotel, they would be responsible for paying for it. Did you have a question back there?
Yeah.
I have two questions. First question is the pet can be any pet, or pit bull also be a pet, or service animal, or there's a special kind of dog that they are the ones?
It can be any breed. I literally was just advising on this 2 days ago. It just has to be, and like I said, it just has to be trained to perform some sort of function, and the training can be done by the owner. It doesn't have to go through any sort of special school.
The second question is, can we charge the pet deposit or incidental fees for service animal that, hey, you're going in a room with your pet, so I have to charge you $250 pet deposit or something?
I don't think so.
Because we do charge for other pets.
Right. It is not a pet. It
Yeah, I
is-
don't believe you can charge a deposit for an animal assistant or a, yeah, I think the answer to that is no.
One back in the back.
Is there any way we can post a notice at the front desk to third desk like lying about a service animal in prostitute or something? Because a lot of time we get, it's an emotional support animal, and they don't know. If we try to educate them, it's a difference between emotional support and service.
You're right. There is a difference between emotional support animal and a service animal, and it's actually different in employment context versus the public accommodation context. But there actually are several states now that have laws. If you try to fraudulently pass off a pet as a service animal, they can get prosecuted. I don't know how many states, like 18 or something, but it's growing because I think probably people have lobbied that because it is an issue, particularly in hotels and restaurants where people are bringing in animals all the time. But but I do have signs. I have had clients that have signs, service animals only, but I think, if you ask the person if they can't identify the service that the animal is trained to perform, then you can say this isn't a service animal and you could charge them a fee.
We ask them telling me the problem, we can just display a sign, and it is up to them. Can it be possible? Do we have some signs like that for front desk?
Well, you can have the sign, but if somebody's coming in with the animal, I guess it depends on your policy and your procedure. If you just were automatically charging them the pet fee and then they say, no, this is a service animal, then you could ask the question. I think I just know you can't ask them if it's, ask them more, like what is the disability, where are its papers, anything like that,
You can't push back. Like
Right.
if
There's not a
they
lot of
say it,
pushback.
you can't push back.
I got, sorry.
You guys saying that we can have a bullet point in our reg card, on a digital reg card or whatever reg card we have, that hey, in the state of South Carolina or Florida or whatever, says you can be, if you giving us wrong information or about the pet, you'll be charged for 14 days in jail, whatever the the code is. We can put that one as a bullet point and let them initiate it, right?
I don't see what would be wrong with that. If that's what the law is in your state and it says you will be fined, you could be subject to whatever. I don't know what the penalties are in all the different states, but that's just like saying if you're smoking in the hotel and it's a no smoking room, you're going to get charged whatever amount of money. I don't see that would be any different.
Yeah, thank you. I got a question. There are two questions we're allowed to ask.
Right.
And one of the question requires the person who's carrying a service dog to release their medical information. And in that, sometimes because our clerks are not that acquainted or trained to ask in that professional manner,
Right.
wouldn't that be subject to the violation of the HIPAA law?
So
And there is, by the way, there is a lawsuit for that. If somebody disclosed the medical information and they broke up with their girlfriend.
a couple of things. So that is a very important point you brought up. Train your staff. Train your staff about these questions they can ask. They can ask, is the animal a dog or small horse? There was this very famous service pony, Tony the Wonder Pony. He had his own YouTube channel. He used to visit lots of places, but mostly a dog. Is the dog used for a disability? You do not ask what the medical condition is. You just say, is this for a disability? And they can say yes or no. Like, it is literally, that question is a yes or no. And then what is the service the animal has been trained to perform? And that's the thing, is nobody wants anyone's medical information, but also HIPAA only applies to medical places. It's not on, hotels should not be subject to any sort of HIPAA violation.
One thing I wanted to add real quick, just to piggyback off of that point. Yes, absolutely. From a training standpoint, from a policy standpoint, whether or not your franchise has one, it's a great idea to have your own policy, have that reviewed for your state law, because and Jen mentioned this, but all states are different, right? So, you got the ADA, which is sort of a federal floor, but, the state might set a higher ceiling, right? And so even when it comes to these animals, like in Ohio, it can extend to some exotic animals. I mean, I've seen scenarios where there's a peacock. Imagine, right? So it's something that it's important to take a look at that, right? And just, training your staff. I could see your guys' reactions when I said that, right? Imagine your staff when they come in. If something like that were to happen, I think it's very important, that training process, so that they're aware of it, they know what to expect. And yeah, absolutely. I mean, policies, procedures, one of the themes for today. For sure.
And I've seen it tons of times where the hotel actually has the right policies in place. And I mean, I'm sure you have lots of turnover, right? The front desk staff, maybe they just missed that day, they weren't paying attention or whatever, and then they've asked the wrong questions, or they just flat out refuse, or they just say, no, we're charging you the pet fee, and you wind up with a lawsuit or a demand letter or something like that.
I'm just going to jump in here, just because we're getting short on time. Let's take one more question on this.
We'll also be available afterwards if you want to ask us
absolutely.
questions.
Go on.
So the question, is it okay for us to share that guideline, maybe putting it in one page, under what circumstances the service animal can be removed, and follow those guidelines, the federal guidelines that are printed? Is it okay for a property, so when somebody checks in at that time, we just ask them to initial that page, attach with the reg card, and give them a copy? Just more of a reason, because a lot of frauds are occurring, right? We all want to comply with the law, but at the same time, it's more of a psychological peace of a mind, because a lot of time they put a service animal in the room, just like you said, I'm going to go for a dinner and come back. So is it okay for property to share that information? We're not asking them. It's like, I have shared this.
I mean, and then I think that's a similar question. I think that there's nothing wrong with sharing. These are the circumstances that an animal is not considered, or a service animal must be under control, must be housebroken, these kinds of things. I don't think there's any problem with providing that information to someone, like you said. It's like a psychological thing. They know this is there. I haven't really looked into, can you make them sign an agreement saying, and if the dog does these things, the dog will be removed, or we will be charged the pet fee. So I cannot advise definitively on that piece of it, but I have no problem with, they were asking about the res card, if you say that, fraudulent passing off of a service animal is subject to this kind of fine. If you're just literally listing the law, I don't see what the problem would be for that. But I just don't know about the agreement, or then taking steps because the animal has violated that.
So guys, this is obviously a great discussion. Like everyone said, we're here after if anyone wants to continue this, but maybe Anand, you can jump in on, pick one.
Talk about the mechanics line.
Okay.
Real
Yeah.
quick.
Yeah, so great discussion. We wish we had more time, honestly. We were given 45 minutes, so we'll try to operate within that, but yeah, we'll be available. So mechanics liens, all right. This is something that really applies if someone's come onto your, there's a contractor, company, individual that's come onto your property, performed work or provided some sort of material and hasn't been paid. And under what circumstances, I'll kind of speed through it, but essentially every state has a time limit to when you have to file these liens, right? It's generally between 60 to 120 days after that work was either performed or that material was provided for some improvement on your property. Liens, they're sticky, and they literally stick. I mean, in Ohio, 6 years, give or take a year or two here across the country. And if you're buying and selling, it's going to come up, right? I mean, and the worst thing about ignoring a lien, and look, you may have paid your general contractor who just didn't pay the subcontractor, right? So it might not be your fault, but if you ignore it, it's something that's going to stick around. And let's say you want to turn around and sell your property, it's going to come up on a title search, right? It's going to become a lien, it's going to become an encumbrance that you now have to address. And you can say, okay, well, the lien was 15 grand. All right, I'll go ahead and take care. What if you can't find the subcontractor, right? That filed the lien. Now you have issues. Maybe your buyer's lender has a problem with it. Maybe the deal falls apart. And look, over something like 15K, maybe that's not going to be the case, right? But these can be larger, they can be smaller, but they're certainly an annoyance if you don't take care of them, and they can have an impact, right? They can have an impact on your freedom to be able to buy and sell. I think particularly because sometimes it can be hard to track down these subcontractors. So keep that in mind. Some of the things that you can do is from a contract. So often in this realm, someone will send me some information. I wasn't involved on a contract side. I say, okay, where's the contract? And they'll send me a purchase order. And I look at it and I'm thinking, well, all this has got is, what you've bought and how much you've paid. It doesn't have the actual contract language that you would want to have in place in order to protect yourself, right? Indemnification language, which Marissa mentioned earlier. There should be, some sort of requirement for the general contractor getting lien waivers from their subcontractors, right? If you've paid the GC and the GC, is paying the subs, well, the subs should already be required, right, to provide the GC with those lien waivers and then to you, right? So I think it's important, especially on larger scale projects, to incorporate that in your own contract with the GC, but also maintain the right to review their contracts with the subs so that you know that there's proper flow down, right? That's not just from a lien standpoint, but also insurance, right? Adding the additional insureds. If there's someone that comes on, a subcontractor comes on, there's some sort of personal injury. These are all coverages you want to have. You don't want that uh-oh moment where you're turning around, sending this over to your counsel and they're saying, well, it's not looking too good here. So that's what I kind of wanted to mention about mechanics liens. That's sort of the long and the short.
Yeah, if I can just jump in, another sort of best practice overarching that's not just specific to mechanics lien. This may be stating the obvious. Save all your documents, please. And any agreement, any amendment to an agreement, any email. Candidly, even if you think it's a document that could hurt you, it would likely be much worse if you are deleting documents. And look, depending on where you are, if you're threatened with a lawsuit or a claim of any kind, you can get into big trouble for deleting things. So again, that's a little bit of a tangent from where Anand started, but it really is best practice. Save all your agreements, save all your correspondence, save all your emails, and especially if it looks like you're about to be hit with any sort of proceeding or lawsuit.
I also wanted to touch base real quick on garnishments because this is something I've seen a lot, not just in hotels, but everywhere. a lot of times people get notice of a garnishment, and someone wants to garnish the wages of an employee, and they're like, well, this employee doesn't work here anymore. Like, this is stupid. And they just literally ignore it. And I have huge corporations who do this. And because they're like, what am I supposed to do with this? This person doesn't work here. The answer is you have to do something with it, because the garnishment laws are super draconian. And if you do not respond to the court and say, this person doesn't work here, or if they do work, they're actually, abide by the garnishment, then you could be on hook for that employee's entire debt. I had someone come to me, and the employee owed $36,000, and they were supposed to be. The person didn't even work there. We're able to negotiate it down, but the laws are really strict in that area. So this just goes back to if you receive something, let someone know. Like, don't just disregard it. Which is the first thing here, because even if you think it doesn't apply to you, it could.
Yeah, I mean, I think we've said it a few times during this presentation, but that's how important it is. Don't sit on legal papers you receive, and keep all correspondence.
And if we want to scare you just a little bit more, we can talk about
Yeah,
it.
that's not the point of this seminar, candidly.
No,
it's
this
not
part-
to scare everyone in this room, but if you take these takeaways, you could prevent a lot of problems in the future.
Yeah, there's nothing that I needed to add there. I think when it comes to one of the last bullet points, being prepared to provide supporting information and documentation, really quickly, when it comes to misclassification,
Yeah, that's what we're talking about.
we've got non-exempt and exempt. And, I
A
usually
lot
like
of times people confuse salaried and hourly. They are not exactly the same.
and a lot of times in this area, I like to say, look, you either log or you lose, right? The states are going to be different about what your requirements are. But, if you're out in California,
Anyone here in California?
Yeah, I imagine this is something that out there, it's really the Wild West. But, you've got to log, you got to have your employees logging those breaks, logging when they're coming in, coming out. I mean, if you don't, the law basically says that the court's going to take the employee's version of that. So good luck with that, right? If you don't have a rebuttal, it may be time to look into some Jaiwala stations, But seriously, think about that. Try to get the documentation that to support that aspect of it.
And as we were talking about, auditing your parking lots and things like that, you might just also want to audit, especially like your assistant managers, and see, are they really exempt or non-exempt? Have you classified them correctly? That's the job title I feel like we see a lot where it's misclassified, and you just run the risk of a potential lawsuit for like old overtime wages and things like that.
Yeah, and these are 7-figure settlements or
Well, and
even
that's generally
judgments,
in like a very big, lots of employees.
But still,
So,
yeah,
just so you know.
but especially out in California, pretty easy to get there. You could have a medical practice that gets there with just 3 or 4 different employees. Because a lot of them, the multiple employees will join in. You've got a lot of provisions there: liquidated damages, attorney's fees. So it can be very, very expensive. So keep that in mind.
I promise you, we did not make this session to scare everyone in this room, just to reiterate. Okay, so I think you guys actually hit most of the things on this last slide, and we have 2 minutes. But like I said, we're happy to stick around after. We just have 2 minutes left, so yes?
Can you kind of review a little bit about, what to do if there is a complaint in-house? For example, me, let's say I am ADA and I fell in the bathroom. What are the requirements for us as owners to train our staff? So if you can kind of.
So like general liability, like just anyone slipping and falling?
What are the guidelines that we need to follow right after we get the call?
So I'm guessing everyone didn't hear that. So I think if I heard the question correctly, it's just a general question of, if there's a slip and fall, like what are the guidelines for like training your employees? Anyone want to speak to that?
Like I call you stating, hey, this is what call we got and this is what happened. And you're like, did you do this, and this? That kind of question. Like, can you kind of
This is not really my area.
Yeah, I mean, I think it's difficult to really answer that question directly. I think in general, you want policies and procedures in place for incidents that happen on your property, and you want to train your staff.
Right. And then you want, yes, you want to
Yeah,
notify
and
them
you bring
and-
up a good point. So let's say you have one of these incidents on, like a slip and fall. I mean, there's a notice provision, there's a notice requirement with your insurance carriers, right? You need to notify them in time. And if you don't do that, well, your claim you could have an issue having your claim being covered, right? And then all of a sudden you're talking about out of pockets, right, for legal expenses versus. So that's something to keep in mind too. And I did want to
Yeah.
bring that up. So I'm glad
And
you asked
on that
question.
note, a lot of times insurance does cover, if you do have insurance coverage for employment, you've got things, they usually don't cover wage and hour things, but I've had lots of Title III cases that are covered by insurance. So check your policy if you ever get notice of an issue.
What would be your best suggestion nowadays? Pretty much all the PMS are cloud-based, so you have your front desk supervisor or your manager or a front desk employee. Let's say somebody makes a mistake, you need your help. Either they're hourly or salary, but if they log in from home to fix a problem, we want to make sure that they do get compensation properly. What would be the suggestions that, or have you guys come across a case that we can learn a better policy to manage?
Well, whatever time your staff or employees work, you got to pay them for, right? So it's really about the methods that you have to make sure that
track
that's
that.
accurate, right? Correct. So it's sort of a difficult question to answer from a broad standpoint or from a narrow standpoint. Broadly speaking, though, it's you got to pay them for whatever they work, right? And it's important that you follow up with them and make sure that they're logging their hours.
But yeah, you don't want to get later on a off the clock claim, like I worked all this, and because they're still entitled to get paid for it. And then also you can't, like even if you say no overtime and they work overtime, you still have to pay them for the overtime.
Paying is not the issue. What would be a good policy that you guys would suggest that we can manage and we can have?
So
I was gonna say,
you go ahead.
I was gonna say, if you have to, you can have it more from like a discipline standpoint. Like if you are not logging your hours
Right.
correctly, then you're gonna get written up.
Yeah, so like a progressive discipline policy, right? So if you haven't done it on this occasion, you get a little, document in your file.
Still have to pay them, but you might be
Still-
getting
yeah.
a write-up.
Still got to pay them, but then you can write them up, right? And in accordance with that separate progressive disciplinary policy, you can start to take action, right, for some of those shortcomings.
Maybe counsel out those employees who keep trying to do that.
We have so much choice to pick the right employee nowadays, right?
That's the thing, is it's really tough. Has it gotten better? I feel like it's just anecdotally, it seems that I've seen fewer like desperate help wanted signs. And, from clients, it sounds like it's gotten slightly better.
Guys, I hate to do this, but we are out of time for this session. I really thank you guys for being so interactive. This was great from our end. And again, we will be outside.
The
I
last thing that I want to jump in and say, right, as you guys are walking out, so that your whole walk down the hallway, you're thinking about this, is to be careful what you write. Texts, right, emails.
Texts are the bane of my existence.
They are going to be exhibits on litigation.
The E in email stands
So-
for exhibit.
Yeah, it's horrible. And so just keep that in mind when you're writing something to your staff or whoever it might be. That could be used against you at some point. So just be
You
careful.
can always
what you write.
copy your attorney. Make it.
Guys, last thing, please take the survey. That is my last requirement as a moderator. It's on your screen. Thank you so much.
Thanks,
Thank you
y'all.
guys. Appreciate it. Have a good rest of your conference.